Ladies and gentlemen, hi, welcome to lawcaseuk.com and welcome to the Law Library here at the University of Surrey. Today I'm going to be examining briefly three cases from the 17th century in which Sir Edward Coke presides over decisions relating to the use of both executive and legislative power. The cases are all interesting as they involve judges grappling with constitutional law issues which touch upon the notion of separation of powers. Now, I was inspired to do so because of references to one of these cases in the recent 2017 judgment in Miller and the Secretary of State for exiting the European Union. And the case that's referred to in the 2017 judgment of Miller is the 1610 case of Proclamations, and that will be the first case that I look at today. Now, I've chosen these three cases for a number of reasons. Firstly, the judgments themselves, whilst they're short, they're not easy to decipher as they're written in the language of the day, and I hope that I can give you some assistance in that respect. Secondly, contextually, the 17th century is a particularly important time for the development of the Constitution and constitutional law. It begins with James I on the throne and ends with James II leaving the throne on the advent of the Glorious Revolution. In between these times, we have civil war, we have the removal of the monarchy and its eventual restoration. And so for that reason, this is a really interesting century to look at. I also thought, as a third reason, it would be interesting and valuable for you to see these three cases discussed in one particular place. So let me begin in 1610 with the case of Proclamations. Here, Sir Edward Coke, who at the time was the Chief Justice of Common Pleas, he was asked by the Lord Chancellor and others for his opinion on whether the King, James I, by his proclamation could prohibit new building in and around London. And here the proclamation is an order by the King to make new law in effect, and that new law would prohibit building in and around London. So the case here is not about whether that prohibition itself is valid, but more about the way in which that law would be made. In effect, whether the King had the power to make this law in this way without the support of Parliament. Because it was accepted in the case that were he to do so with Parliament's support, then of course this law would be a valid one. But the question was, could he do it in his own right? Now, like the 2017 case of Miller, Proclamations is an example of the judiciary adjudicating on the allocation of power within the Constitution. And like the judges in Miller, we see Coke considering the prerogative power of the executive. For Coke, the executive is the King, but when we look at the 2017 case of Miller, of course, the executive then is cabinet government. Now, in the case of Proclamations, looking at this notion of prerogative, Coke famously stated that the King hath no prerogative but that which the law of the land allows him. Now, the Lord Chancellor, who spoke in support of the King, argued that the King did need such a power, even if it had not been used before. And specifically, the Lord Chancellor said something to the effect that every precedent had a first commencement. And by this, he was endorsing a power for the King to make new law, even if he had not used such a power before. But Coke and his fellow judges were against the Lord Chancellor on this. And they resolved that the law of England is divided into three parts: common law, statute law, and custom. But the King's proclamation is none of them. And they went on to say, the King by his proclamation or other ways cannot change any part of the common law or statute or the customs of the realm. And this statement of law, ladies and gentlemen, remains relevant today in that case of Miller, because Proclamations is mentioned there 8 times, and it begins with Lord Newburgh his judgment begins with that quote from the case of Proclamations. So in that sense, Proclamations is a relevant precedential case today. Now, the similarity in the cases is not just that they involve this exploration of prerogative, but also that they are exercises in deciding the separation of powers issues. And moving from Proclamations, a similar exercise in allocation of constitutional power arose in the slightly earlier 1607 case of Prohibitions del Roy, which is also called the case of Prohibitions. Now here again, Coke makes a separation of powers determination. This time he does so on the basis of competence or institutional expertise. What happens here is that the king had been a judge in a property dispute, and the question was whether he was competent to do that. The king, in his explanation, I hesitate to use the word defence for a king, but he said that he thought the law was founded upon reason, and that he and others had reason, as well as the judges. But to this, Coke answered, God had endowed his majesty with excellent science and great endowments of nature, but his majesty was not learned in the laws of his realm of England. And he went on to say, causes which concern the life or inheritance or goods or fortunes of his subjects are not to be decided by natural reason, but by the artificial reason and judgment of law, which law is an act which requires long study and experience before a man can attain to the cognizance of it. And of course, that's why we're on this arduous journey of law students to obtain the wisdom that Coke was identified as being beyond the reach of kings or queens, for that matter. But obviously I say that a little in jest, so don't quote me on that. But it demonstrates that law is a specialism and also has this artificial reason that the king was not learned in. Now, as you can imagine, because this is James I, he was offended by this, as it suggested to him that he should be subject to the law. And he felt that to be a treasonable suggestion. And remember, he was a strong believer in absolute monarchy, and he himself had written a treatise on the divine right of kings. But notwithstanding the potential danger of doing so, Coke then quoted the medieval jurist Henry Bracton by saying this: the king ought not to be under any man, but under God and the law. And that, of course, is a great rule of law quote for us to use. Now, the ruling in the case is to the effect that the king, of course, cannot, in his own person, judge any case, and that ought to be determined and judged in some court of justice according to the law and customs of England. In support of that contention, Coke suggested that no king after the conquest assumed to give any judgment in any cause whatsoever which concerned the administration of justice within the realm, but these causes were solely determined in the courts of justice. So in terms of justifying his position, Coke was suggesting it had not been the practice of kings since the conquest to sit in the courts. And not only was it not practice, of course, they were not qualified to do so. So that's our second case. The final of the three cases that I'm going to review is that of Thomas Bonham and the College of Physicians. Now, this is another 1610 case, but it's better known by its short title of Dr. Bonham's case. Now, unfortunately, I'm unable to provide a link to the judgment on this website, but I have based the analysis that I offer here on the report that appears in the English report series, and I've accessed that via Westlaw, so you should do so also. Now, the case title suggests that Bonham was, as he was, a doctor. But the thing about Bonham was he was not a member of the College of Physicians, and it was their responsibility to license people to practice. Now, as Bonham was practicing without their authority, they fined him, and then they later caused him to be imprisoned. As a result of that, he sued for false imprisonment. Now, the college sought to justify its actions by reference to the charter that had been accorded to them by Parliament. Now, this charter is akin to a statute, and so the court set out to interpret its meaning. And the majority, led by Cook, decided that the charter did not provide the college with the power to order imprisonment in these circumstances. And so far, whether we were to agree with that interpretation or not, there is nothing startling, even in 1610, about judges interpreting Acts of Parliament. And if the matter had ended there, probably we would not have heard of the case. But what has made it infamous is that during his examination of the statute, Cook noticed that it allowed the college to be both a party to these disciplinary proceedings and the judge in those disciplinary proceedings. And this he considered to be absurd. And on this aspect, we would agree with him today, as it would offend the principles of natural justice. But here it was not necessarily, or not strictly necessary, for him to decide the case. And therefore, what's about to follow should probably be regarded as obiter dictum in the case, rather than the ratio of the case. But what Cook famously went on to say was this: "It appears in our books that in many cases the common law will control Acts of Parliament, and sometimes adjudge them to be utterly void. For when an Act of Parliament is against common right and reason, or repugnant, or impossible to be performed, the common law will control it and adjudge such act to be void." Now, today, any suggestion that the common law could void a statute, an Act of Parliament, would be a radical one. 1610 is, of course, before the Glorious Revolution and the eventual identification of parliamentary supremacy, but even in 1610, this is a controversial statement for Cook to be making. But when we look at it today, it doesn't have the precedential currency that, say, the case of Proclamations has. It's largely been overtaken by the Glorious Revolution. For example, in the 2005 case of Jackson and the Attorney General, a case which I will analyse on this website, even there, when some of the law lords suggested that parliamentary supremacy might be subject to common law control, none of them used Cook's dictum from Dr. Bonham's case in order to support that position. So, whilst it's a dictum that's often quoted, perhaps the importance for us lies in recognising that even if Cook intended those meanings, or that meaning of those words, we can consider it to have been overtaken by the Glorious Revolution and the settlement that followed. So we can contrast that with our first case, such as the case of Proclamations, because that case, the revolutionary settlement supports that case, and therefore it remains a precedential effect, and that's why we see it quoted in Miller. Now, before I leave Dr. Bonham's case, I should point out that there is a further controversy that surrounds it, and that is the extent to which it can be taken as inspiration for the type of judicial review that one sees in the United States. And there is an interesting debate on that, but as that debate is outside the analysis of the case report, it's outside the raison d'etre of this website, and therefore I'm going to mention it, but then sidestep it on that basis. So those are the three cases, ladies and gentlemen. They show how the senior judiciary were grappling with separation of powers issues that were indicative of a tension that would eventually lead to civil war, and then finally the Glorious Revolution, the establishment of a constitutional monarchy, and a settlement in which the independence of the judiciary is secured, and Parliament then becomes the supreme lawmaking institution.